Welcome to Case Flash, brought to you by the CBA Family Law Section. I'm Sam Schoonmaker, and with me today are attorney Alan Palmer and Barbara Aaron. Today's Case Flash addresses whether a trial court needs to make an earning capacity finding of amount before ordering alimony or child support based on earning capacity. First, the basic facts in Tanzman v. Meurer. The parties divorced in 2006. At the time of the divorce, the trial court awarded unallocated alimony and child support in the amount of $16,000 per month, based on Mr. Tanzman's earning capacity. The trial court did not find the amount of Mr. Tanzman's earning capacity, but did indicate in the decision that historically he had earned about $988,000 per year. However, the court also found that due to changes in the day trading industry, Mr. Tanzman had lost his job and would have to adapt and find a job in another field. Mr. Tanzman moved to modify less than 2 years after the date of dissolution. He conducted a job search, which resulted in him obtaining a $100,000 per year job, which was significantly less than the $192,000 unallocated alimony and child support award. The trial court found that Mr. Tanzman's earning capacity was unchanged and that his new job did not maximize his capability. Therefore, it found that there was no substantial change in circumstances. Mr. Tanzman appealed and thereafter repeatedly tried through motions for modification, motions for articulation, and for review to get a earning capacity finding of amount from the trial court. The appellate court twice ordered the trial court to find an amount. Ultimately, the trial court ruled that it had never found an amount of earning capacity. It just had found that Mr. Tanzman had not maximized his earning capacity. The appellate court affirmed, reasoning that earning capacity is a flexible concept and that the trial court was not required to make a specific finding of amount. The Supreme Court granted certification and then reversed.
I think that the majority opinion really recognized the impossible situation that Mr. Tanzman was put in seeking a redress on a motion to modify, and that if there was no that the trial judges really need to specify the basis for their findings, and especially in an earning capacity. If you're going to make a finding that somebody has obligations based on earning capacity, you need to give that person what the threshold is of their earning capacity so that they can either meet that or come back on a modification to know what in fact that baseline is. They really did put him in an impossible situation without articulating what the basis of the earning capacity was, what the amount was.
I think the Tanzman decision is a victory for common sense. You would think that the basic definition of earning capacity is that it is an amount that a party can realistically be expected to earn. So the basic definition of earning capacity includes the word amount. So it would seem that this decision really is a long time coming, because it would make sense that the court would have to specify a dollar amount in order to establish an earning capacity.
From the perspective of the trial court judge, let's say you're not the judge who tried this case in 2006, you're a new judge, and this motion to modify comes before you, and what are you modifying from? Is earning capacity based order, but what's the baseline? So how do you, as a new trial court judge, how do you deal with that? As in the appellate court, how do you review it? If this is reviewed under the clearly erroneous standard, but there's no finding, then how do you review that under the clearly erroneous standard? So for all around, it just makes a lot more sense to have an actual number.
Or a short, or a small range.
Or a small range. The majority talks about a small range in one of the footnotes, but it looks like it's actually leaning strongly toward a specific number if it can be found, which is consistent with the way the law is going on child support guidelines, Meurer and Crayfick. So that's the way the law seems to be going, and this is another case that's consistent with that developing body of law.
What's interesting, I think, about this case is that neither the trial court nor the appellate court nor the dissent come out and say that Mr. Tanzman was willfully depressing his income. What they said is he wasn't doing all he can to maximize his income. So in that sense, I think that the trial court and the appellate court simply applied the wrong standard. I mean, that's not the standard. What if he wasn't maximizing his own income because he wanted to spend his afternoons with his kids because his parenting plan allowed him to do that? I mean, there's lots of reasons why you're not maximizing your income that has nothing to do with earning capacity.
Right. I mean, people make all sorts of professional decisions. A decision, let's say, to be a judge rather than a partner at a major law firm. Wouldn't that be a decision that's contrary to maximizing your earning capacity? And also, isn't there a supply and demand component to this? And there's the line of cases that say if you voluntarily cut back on your work and your earnings, then a finding is based on earning capacity. But there's also a reality of supply and demand in the marketplace where jobs go away. Industries go away, and isn't that in part a recognition in this case?
You may be educated as a doctorate in some fancy field, but the jobs that may be available to you is flipping burgers. I mean, I think that's a really serious component of this, because you can't, while the court can say you're not trying hard enough, the court cannot invent a job for you unless they hire you for the judicial department. So without that, I don't know how the court invents a job for somebody.
What I think is most interesting in the decision is the footnotes, and particularly footnote 6, where they really do talk about the two-prong test and for the modification, one being that you have to prove a substantial change of circumstances, and then in determining the earning capacity, that it's a flexible, actually what the court was talking about is the flexibility that the trial courts have, and the flexibility is with respect to establishing the earning capacity at its threshold, in which the court can consider things like age, health, station, all of those statutory criteria, but that ultimately, on the second prong, what the earning capacity is has to be a definite number. And what's curious here is that how do you do one now without the other? And the question that I have is, don't you really need an expert on both of those prongs?
You need an expert in the absence of historical evidence.
In the absence, I'm sorry, yes, in the absence of historical evidence.
A series of tax returns, for example, might be historical evidence. But you're talking about in a situation like this where the argument is that the industry has gone away, the job you used to have has gone away. Then you need an expert.
The more serious concern is, in this particular case, the industry changed, essentially evaporated, and the plaintiff had actual earnings which, in my mind, should have substituted for the earning capacity. He had a full-time job. Nobody said at this point he wasn't showing up to his full-time job. Why didn't the $100,000 actual earnings replace this amorphous concept of earning capacity that was undefined by the trial court?
Well, if you have if a award is based on earning capacity and then someone gets an actual job, is that necessarily a substantial change of circumstances?
Necessarily no, but can be yes.
Can be. So, I mean, someone could conceivably get a job that is for less than their earning capacity, and then I guess the proof would be that this job is below their earning capacity. But I'm wondering if just the fact you actually have a real job instead of a imputed income, if that itself is a substantial change, because it's now something real in place of something that's imputed.
Well, but I mean here, there wasn't. I mean, at the time of the judgment, his self-employment income was in the negative, and at the time of the modification, he was making $100,000, and it wasn't in the financial field. But the court, really, the linchpin of the trial court's decision, and actually the appellate court's decision, and I think part of what the dissent is saying is, because he wasn't seeking to maximize his income, nothing else mattered. You don't get to the second prong of the test. You don't get to apply the statutory criteria. You don't get to establish anything other than that he wasn't trying hard enough to maximize his income. And it didn't matter to the court that he actually had a job making $100,000. It didn't matter that the sources of all of his income at the time of the modification were very different than at the time of the judgment. And in fact, the $800,000 that the court found at the time of the modification was really, other than the $100,000, was assets that he had gotten during the divorce that were awarded to him at the time of the divorce. So that wasn't even considered by the court.
So on remand, there might be a claim of double dipping, because why should Mrs. be able to benefit from assets that were already divided in a previous hearing?
What did we like about the dissent in this case?
I think the dissent, as part of the larger argument, makes some valid points. But I don't think they follow it to its logical conclusion because, as I indicated previously, the underlying definition of earning capacity assumes an amount. And the dissent basically said that he wasn't trying hard enough at the time of the original decree. Nothing's changed as of 2008. He's essentially engaging in culpable conduct. We're not going to give him the opportunity to establish anything more.
But what we did like is the first part of the question, it was really a concurring opinion because the dissent agreed with the majority
Right.
that the answer to the certified question was no, that the trial court does have a responsibility to find a specific amount of earning capacity.
Right, so there's unanimity that there should be a specific finding, that
Correct.
it's an amount.
Right.
It's not just some amorphous concept of
Right.
you should earn more. It's a dollar amount.
It's a dollar amount. And the question that it poses, though, is it's much easier to do that, as you said, when somebody willfully quits their job or there is a tax returns or record. What do you do in cases where somebody's been out of the workforce for 15 years or 10 years, has a degree, an advanced degree perhaps? What now is the criteria used to define what that earning capacity is? And how much does one's age matter? I mean, all of these things that the court continues to say are flexible, and that the trial court can use all these flexible criteria, but how flexible is it really? I mean, don't you really need to have expert opinion and really hard evidence rather than simply a finding?
And without bringing in potential employers as to a possible job, I believe the expert would also have to opine as to what's available in the marketplace for someone with particular skills.
Mm-hmm. What was the remand in this case?
The remand is interesting, and it's or twofold or threefold. The trial court's going to have to establish the earning capacity, the specific dollar amount for the earning capacity as of the date of the decree in 2006, as of the date of the modification hearing in 2008, and presumably to enter current orders as of 2013 when it ultimately is reheard. As a practical matter, this isn't the only earning capacity finding out there that looks like this. If you had a client who had an earning capacity established where no number was set forth, do you now tell him to go in and try to modify or to bring a motion to clarify?
I guess you should bring a motion to
A motion to
clarify.
clarify.
Yeah.
Which you can bring at any time, and you would need to do that.
And that is a real challenge for the trial court judges. A motion for clarification can be brought at any time. This decision is very clear in saying that it can be brought at any time. But if you're a trial court judge who rendered an order based on earning capacity 5 years ago, and someone comes in with a motion for clarification, it's going to be a very difficult motion to resolve on a busy docket.
I mean, the fiction here also is coming up with a specific number. Because, I mean, as a practical matter, it's arbitrary. It can't be anything other than arbitrary unless somebody really did quit their job last week in order to not meet their obligations. But in a case like this, earning capacity it has to be, as a practical, a range. I mean, without a specific finding that there's a job available and that this litigant is qualified for that specific job, it really is on some level an arbitrary number, unlike CRAFIC or pension valuations or valuation of other assets, which you really can fix by a specific number. I mean, I think that's the more difficult part for trial judges here, is if they're going to come up with a specific number, they're going to have to, in some ways, engage in a legal fiction.
Well, isn't that every valuation now? I mean, what is the house going to sell for? We're not sure exactly, but we come up with a number, and this is the number. And in the child support guidelines case, you have to have a number in order to apply the guidelines. You can't even have a range to apply the guidelines. So someone's going to have to come up with, which was not part of this case.
Right.
But I think a specific number makes a lot of sense. It's difficult getting to the specific number, but a specific number makes a whole lot of sense. The Tanzman decision is a very important decision. It's going to change the way earning capacity cases are tried and the way that the council prepares for them. Thank you for watching Case Flash.